So I don't think I've met all of you before. My name is LiaNs. Good afternoon, everybody. I work at the Transboundary Legal Studies Department of the University of Groningen in the Netherlands. And I'm really delighted to be chairing this session of the seminar series, the legal issues arising from networks. And this is a collaborative effort between colleagues across Europe. And for those of you who are new to the seminar series, we have monthly talks by experts on a wide range of topics concerning law and networks. And I will post the link to the website in the chat later in case you'd like to take a look if you haven't already subscribed to our mailing list. But I would like to very warmly welcome today's speaker, Maria Corrêa. Maria Corrêa is a postdoctoral researcher at the Center for IT and IP Law at KU Leuven. And a comparative law professor at the Free University of Brussels, where she also completed her PhD. So today she'll be presenting her upcoming paper, Targeting Online Advertising, Addressing Discrimination in the Goods and Services Sectors. And I have to say, I really enjoyed reading the paper, and I'm really looking forward to the presentation of it as well. And of course, we will have time for discussion after the presentation. So please, if something pops into your head during the presentation, feel free to indicate in the chat already that you'd like to ask something during the Q&A. I think for me, that's it. I will stop here and I will immediately give the floor to you, Anna, and thank you very much for accepting the invitation.
Oh, thank you very much for the warm welcome, Lottie. It is really my great pleasure to be here with you. I will turn off and I will share my screen immediately. Just let me know if everything works. Okay, so here, can you see my screen? Is it?
Yes. Yeah.
Yes, and can you see?
No, but it froze again, just like before when we tried. So when you want to put it in full screen, apparently it.
So perhaps I will not put in the full screen. Okay, we do it again. Okay, let's see. It happens again. I'm sorry. It's going to work out. Perhaps it's going to work now. Okay, can you properly see the slides or?
Yeah, that's fine. Yeah.
That's fine. Okay. Well, there were some animations that I prepared. It won't appear because it's not in presentation mode. But hopefully it's going to be fun enough. Okay. So good afternoon, everyone. So thank you again for inviting me to this seminar. It's a pleasure again to share with you my ideas. I took the opportunity to present my new paper, which is, as I told you, a work in progress and committed to publication, and hopefully it will be out in the next semester. And in this paper, I address the issue of discrimination in targeted advertisements. So I prepared an outline. I will focus specifically on advertisements related to the offer of goods and services. I address in this paper some regulatory responses to the issue of discrimination in the practice of targeted advertisement. And these regulatory responses we may find in the European Union law, but also in other international documents. I follow by telling you some uncertainties regarding these regulatory responses. Actually, one of the arguments of my paper is that these regulatory responses are not sufficient to address discrimination in targeted advertisement. And I conclude my paper and also my presentation today by suggesting some possible remedies to address the situation of discrimination. And these remedies are related to what I call transparency, fairness, and also auditing or situational tests. So I decided to start my presentation today by telling you a story that Sebastian already knows because he was in my presentation last week. But for other of you, it's going to be perhaps a new story. And this story that I'm going to tell you did not happen in the European Union, but instead in the United States. This story could have happened in any member states of the EU, considering that the practice of the company in question is not different in the EU. So the story concerns the practice of targeted advertisement. And I want to tell you that in 2017, the American Civil Liberties Union, which is maybe some of you are familiar with. It's a nonprofit organization founded to defend and preserve the civil rights and liberties of American citizens and non-citizens as well, went after 3 different people in the United States. And these people you currently see in your screen as a graphic representation I created by myself, are actually Suzanne Juliette Mobley. She is an American citizen, self-declared African-American woman, resident in New Orleans. Then Daniel Adrian Mariquez. He's self-declared Latino and resident in Phoenix, also in the US. And then finally, Victor Onure, who is a man, self-declared African-American and resident in Louisiana. So basically, the American Civil Liberties Union went after these 3 people, 3 individuals, to file a lawsuit against Facebook for allowing companies willing to advertise employment offers, housing possibilities, and credit offers to exclude internet users or Facebook users based on their demographic aspects. And in the lawsuit in question, the demographic aspects were their ethnic origin or race, as they call it in the US, their gender, and their age. So basically, advertisers could exclude the users based on these demographic aspects from receiving their offers. So to explain you better, in this specific case, when a real estate agency wanted to advertise on Facebook apartments for sale, they could select and exclude the Facebook users who would see these ads in their screen based on their personal aspects, as I just said. And in the case of Suzanne, Danielle, and Victor, the real estate agency was able to exclude or select users who would receive their ad with a real estate opportunity based on specific criteria, such as users who self-identified themselves in the platform or were identified by the platform as African-American, Asian American, Hispanic, who just spoke Spanish, Hispanic who just spoke both languages, English and Spanish, and Spanish, sorry, and Hispanic with English as a dominant language. What is very interesting about this case is that discrimination against individuals based on their ethnic origin was by no means present in the content of the advertisement. So there were no discrimination in the content itself, but instead in the distribution of the advertisement for the different users of the platform. So for the ones who were growing up in the 90s or the beginning of the 2000s, perhaps, a good representation of discrimination in the distribution of advertisements in the offline world could be imagined through Perhaps you remember that, but these guys in the streets who used to distribute flyers to promote a certain store, a certain brand, or a certain product. Similar to what happened to online advertisement, discrimination could occur in this offline world if these guys handling different flyers decided to not give their flyers to a pedestrian because of one of their protected grounds. So for example, if they did not give a flyer promoting a nightclub to a person with a minority ethnic physical trait. So this is a sort of discrimination that could happen offline and that happens online in our current age. Another possibility of discrimination in the distribution of advertisements in the offline world is by avoiding the promotion of a certain service or a certain good in specific neighborhoods, particularly in cities that are highly segregated in terms of population distribution. So avoiding to deliver to a certain neighborhood offers of products because there is an over-representation of a minority group amid the residents of this neighborhood is a way of discriminating against this group, right? And this practice actually of excluding certain neighborhoods from the offers of advertisements and provision of services is very well known among anti-discrimination scholars as redlining. So for several decades, and I briefly explained this in my article, but for several decades in the United States, real estate agencies and also credit institutions have highlighted maps of cities with a red pen, and here you sort of have a representation of this in your left side. It's a map I took on the New York Times, but companies, they used to highlight cities with a red pen to inform their staff where they should not advertise their housing offers or credit for loans. And this is particularly problematic in cities where the urban development is still very segregated, particularly in the United States between Black and white communities. And the redlined areas were by no coincidence often inhabited by Black Americans. And of course, this reality could be somehow transposed to several European cities, in which, like, we see a sort of segregation in the urban fabric, right? With different minority groups, not necessarily people with the same background as the United States, but we see that the urban fabric is very often very segregated in different European cities as well. And this practice of excluding individuals with particular demographic aspects from the offer of services and products have been a battlefield disputed by between business and anti-discrimination lawyers in courts, particularly in the US, much before the transition of our consumer society to the internet. So this has happened for several decades now, I would say, since like the 50s and specifically the 60s or the beginning of the 70s, when the Civil Rights Act passed and they have completely forbidden this sort of practice, especially in the housing and credit sector. And it's worth noting that open discrimination or overt discrimination in advertisement for the housing sector is a reality that has existed for a long time. And as I said, it's a battle for anti-discrimination lawyers. And in a previous research that I've developed in the framework of my PhD, actually, I found in different online platforms, and one of them is just there in your screen, Craigslist, but I also found in other platforms designed to the promotion of housing opportunities. I could find advertisements with apartment rental offers with open discriminatory statements, such as the ones you see right now in your screen. So, sorry, I could find things like no women of color need to apply, or no immigrants, please, or white only, or no kids, no pets. And I put no kids there because in the civil rights acts in the United States, family is also a protected class in the access to the housing sector. But so this sort of open discrimination always existed and still existed in our online universe. But coming back to our Facebook example of the beginning of my presentation that was litigated in court, in this class action represented by these three individuals that I mentioned, Juliet, Daniel, and Victor, open discrimination was not present at all. So it was instead very hidden behind the matching tools provided by the platform. And it was only uncovered, actually, the practice of discrimination because of a journalistic investigation led by the very famous organization ProPublica in the US. And in the end, there were at least 5 class actions against Facebook for discrimination in the offer of employment, housing, and credit opportunities. But as you know, in the US, we can settle several actions, including the ones against Facebook, because there is on Facebook in the US the possibility of arbitration, and basically the platform very often avoid courts, and in this case the situation was actually settled privately. So the internet, with its tracking possibilities and data collection practices, has increased, and this is one of the argument of my paper, has increased to an unprecedented level the possibility to include and also to exclude individuals based on their demographic aspects from the offer of services and products. And it's true that we should realize that the most important online gatekeepers for information online, and here I cited Facebook, but also Google, for example, is a huge gatekeeper. They have sufficient data from ourselves to decide in a very specific basis who may receive a certain content or not. And this decision may, of course, take into consideration our geographic location, but also our spoken language, our gender, our age, among several other possibilities. And of course, in the context of online advertisement, this is very problematic. But the fact that content is personalized online works on our favor as well in several situations. The internet is like a huge library that needs labels to make sense, right? Considering the amount of information that there is online. But the problem is the distribution of this information can be sometimes problematic in terms of like discrimination against protected classes, for example, which is the case that I address in my article more specifically. And here I come to the European Union. So far I talked a lot about the US, and I brought cases that happened in the US. But obviously, Facebook and Google also gives companies the possibility to target users based on their demographic aspects in the European Union. So Facebook motto is find the right person to your business, and research has demonstrated that over than 70% of Facebook users in the EU are labeled with very sensitive demographic aspects, such as their political opinions, but also their religious belief and their sexual orientation. The case of the political opinion, for example, was the biggest issue in the Cambridge Analytica process against Facebook, because basically they could select the users who had a certain view of politics and influence these users, and some political parties and some agents in the UK, they took advantage of that to polarize these different users. But the reality is that users, not only of Facebook, but also of different platforms, are labeled according to their characteristics by their personal aspects. And here there are 73% related to religious belief, political opinions, and sexual orientation. But when it comes to gender, nationality, and age, the numbers are even higher. That's why when we see ads ourselves, they are normally not very wrong about who we are in the real life. And when I say who we are, I'm referring, of course, to the aspects of our gender, of our age, or the language we speak. My algorithm sometimes is a little bit confused because I am based in Belgium, and I speak French, but I also speak English and Portuguese. So sometimes it's a bit confused, but it's more and more accurate in the sense that they know that I am a foreigner living in Belgium. It's kind of funny that. But these labels, they serve mainly to target not only advertisement, but also content, and companies, they can select users with very specific aspects to target what they want to. And concerning this same research that you see there in your screen, José González Cabañas, to test the statistics, the researchers of this same study, they created an advertisement campaign through the tools provided by Facebook. And they pretended, these researchers pretended they were a hotel advertising rooms on Facebook. And in their campaign that was run in Germany, Spain, but also other European Union countries, they were able to exclude users from receiving their ads with the hotel room offer based on their sexual orientation. So they were able to select the sexual orientation of the users they wanted to reach. So they could prove that their statistics actually was very, very right. And still in the European Union, another evidence that individuals are tagged according to their demographic aspects and sensitive and protected demographic aspects by advertisers was uncovered mainly by data protection authorities in the EU from the different countries, from the different member states. So in the Netherlands, for example, in 2019, the Dutch Data Protection Authority revealed that Facebook used the personal data of more than 9 million people located in the country for targeted advertising without having their proper consent. But the problem was, for us, it was not only their explicit consent, was the fact that these same advertisers were able to select the users based on their sexual orientation. And then I come to the second point of my paper. How is the issue of discrimination in targeted advertising regulated in the EU level? So we saw that in the United States, the civil rights acts that are the federal ones, that are basically their anti-discrimination laws, they regulate this sort of practice. So I was interested to understand how it would work in the European Union context. And I realized that on the one hand, the personal data protection legal framework, and I would like to highlight here the general data protection regulation, applies to this sort of practice with no doubt. But on the other hand, we all know that the prohibition to discriminate against individuals on the basis of all these protected grounds that I mentioned before, including their ethnic origin, the race. Well, race is a very controversial term, but it's the one that we find in different regulations, but also sex, religion or belief, age, and sexual orientation are provided by international and European Union documents. And we can find protection against discrimination in the European Convention on Human Rights, on the Charter of Fundamental Rights of the European Union, and absolutely in the set of European Union equality directives that provide protection with several nuances against discrimination on the basis of the grounds I mentioned. And specifically also in the access and conditions of employment, and to a different extent in terms of who are protected against discrimination in the access of goods and services. And in my article, I restricted my analysis to the EU law. I didn't dig into member states' law. It was on purpose choice. And I wanted to figure out and to understand, is this regulation sufficient? And I was very intrigued actually, because when I started this research, I could realize that in the US, anti-discrimination scholars, they heavily based their arguments on the Civil Rights Acts, on the federal ones, but also on the different state ones. And in the EU, I saw that this discussion was pretty much confined to the data protection discussion. And concerning if these regulations are insufficient, so one of my purpose was to reflect on whether we could count on this framework to address discrimination in the practice of targeted advertising in the EU. And I believe, and I put this clear in the paper, that this legal framework it still offers a lot of uncertainty to what amounts to illegal discrimination in the practice of targeted advertising in the EU. And my argument is twofold in the article. First, I argue that the GDPR does not offer a thick definition of discrimination, and therefore it should be construed in the light of anti-discrimination laws. There is no way to get around this. Anti-discrimination laws, they should be mobilized in order to give a better definition of discrimination in the GDPR. And a second argument I raise in the article is whether the EU equality directives really provide guidance to the context of discrimination in targeted advertisement. And so let's briefly address the GDPR issue. So I realized that consent is the legal basis to the existence of the practice in the European Union. This legal possibility is supported by the GDPR on the Article 6 and 9, and it makes possible actually the processing of internet users' personal data for targeted advertisement, right? And so consent is the legal possibility to process all this data concerning our demographic aspects on the GDPR and to single us out online in the different websites where we are. And I argue that even though the GDPR raises our attention to the fact that processing personal data related to individuals' ethnic origin, political opinions, religion, political belief may give rise to discrimination, and this possibility is not even in the letter of the articles, but instead in the recital of the GDPR. But even if the GDPR says that discrimination may occur related to these grounds, it does not specifically address when and in which situations differentiation based on these grounds should be deemed illegal. And for you who are familiar with anti-discrimination law, you may realize that not all sorts of this, differentiation in treatment is actually illegal discrimination. So my question was, which sorts of differentiations based on protected grounds are actually illegal, right? Or are all sorts of differentiations illegal discrimination? Or when does a differentiation based on gender and ethnic origin, for example, become illegal discrimination? And of course, we know that the European Union non-discrimination framework offers some answers to this question, and particularly not only the framework, the law, but also the construed meaning by the Court of Justice. And we know that this framework did not consider all sorts of differentiation in treatment based on protected grounds, such as ethnic origin, gender, or age as illegal. And I will give you one example of this for the ones who are not familiar with anti-discrimination laws. But we know that, for example, the directive that implements the principle of equal treatment between men and women in the access to and supply of goods and services provides very clearly that there should be no direct discrimination based on sex in the access and supply of goods and services, right? This is very clearly stated on the directive. And this means in practical terms that an individual or a company are limited in their freedom of conducting business and cannot consider the gender of a person as a reason to refuse a certain services or to sell a certain product. So treatment differentiation based on sex is in general forbidden according to the directive and according to the case law. But we know that this prohibition has several nuances. So differentiation based on sex is not always illegal in the provision of services and goods. And this is notably the case when aspects of privacy and decency, for example, are at play. So if I'm offering a room in my apartment and I live with different flatmates, for example, for rental, this would be considered a good available to the public, right? And in this case, because of the principle of privacy and decency, me as a woman, I am allowed, according to case law, to refuse someone to rent it based on this person's sex. So basically, I can refuse to have male flatmates if I want so. And this is a differentiation on treatment that is not, for example, considered as an illegal discrimination. So I presented this example just to tell you that all these granular precisions of which sorts of differentiations based on protected grounds are allowed are extensively found in the anti-discrimination law field. And because of that, my argument is that the fight against discrimination in targeted advertisement must mobilize anti-discrimination law and not only data protection law. And then I come to my second argument. I raised in the article for some of you who could read it, the question whether this anti-discrimination legal framework is indeed applicable to targeted advertising. And here I'm not talking about, of course, discrimination in content or open discrimination, but discrimination in the distribution of the advertisement based on demographic aspects. And I say that because the equality directives, of course, prohibit discrimination based on ethnic origin and sex in the access and supply of goods and services. But my question is, does preventing someone from receiving a certain offer means the same thing as preventing someone from the access to a certain service or good? This is a question I raise in my article. And for only the sake of clarity, for example, when a company excludes female internet users from receiving their ad related to a sports facility, for example, does it mean that the company excluded women from having access to this sports facility? And I really believe that there is room for more elaboration from the part of the Court of Justice, for example, in this regard. And before online targeted advertising having become a big battlefield in the privacy law field and now in the anti-discrimination law, the European Commission had communicated that insurance companies actually are allowed to somehow target their marketing either to men and women, even if they cannot discriminate against these classes when they are estimating insurance primes or premiums. So this happens in the context of the Association Belge des Consommateurs versus the Conseil des Ministres in Belgium. And in the occasion, the Court of Justice decided that insurance companies are completely prohibited to take into consideration the gender of insurance holders to establish their benefits. And this is crucial, especially when we're talking about car insurance, for example, several insurance that could take gender into account. And what happened is that national brokers or national insurance companies across the entire Europe had to carefully adapt to this decision that was held by the Court of Justice. And despite of the obligation of insurance companies to follow the new ruling, because it was such a big change, the European Commission has to issue guidelines to the application of the Directive 2004/113 in the light of the decision Association Belge Test d'achat versus Conseil des Ministres. And they claimed in these guidelines, the European Commission claimed that the directive does not apply to advertising. More specifically, the guidelines, they say actually that it still remains possible for companies to use marketing and advertising to influence their portfolio mix. For example, by targeting advertising at either men or women. And the guidelines say in the end that these insurance companies may target their offers based on gender, even if they cannot differentiate the amount of premiums based on that same ground. But this interpretation, in my view, was given in a context in which targeting possibilities were much more limited to what we have right now on the internet. And I believe this interpretation may be reviewed, may have to evolve actually to our new reality. But the truth is that what we have now in terms of regulation and in terms of understanding of this regulation offers uncertainty and to what amounts to discrimination in targeting practices. And now I come to my last point after showing you the state of arts and the framework that regulates this state of arts and situation in Europe. I come to the remedies and to the last point of my article. I suggest that the fight against discrimination in the practice of targeting advertisement might produce some results with the implementation of three different measures, and I call these measures transparency, fairness, and auditing. I have a very practical background of what I mean by transparency and fairness. And I will start by transparency. So as you probably know by now, one of the main problems of targeted advertising is the opacity of the criteria chosen to deliver a certain offer to a specific internet user. So this matching operation is undertaken outside, completely outside of the view and awareness of internet users. We are not really sure which criteria were used to target us, right? And this opacity prevents internet users and interest organizations from awareness of potential discrimination by targeting system. And to address this opacity, I suggest in my article a model of regulation that really pushes the principle of transparency even further to what concern protected grounds provided by anti-discrimination laws. And by transparency, I mean actually that companies, they should have the duty to provide a clear statement on the protected grounds they use to target their advertisements. And I believe that this transparency duty might shed some light into the opacity of the criteria used by targeting tools. And I was deeply influenced by the regulation that promotes fairness and transparency. This regulation passed in 2019. And basically, this regulation does only apply to B2B, to business relations, and not business and consumers. But basically, the regulation actually requires intermediary services to disclose their criteria of their ranking system. And this is very important, considering that the order of results we have on our screen has a direct impact on the frequency that a certain link will be clicked, for example. And this is very important for example, competition measures, competition law, right? And while there was the decision related to Google very recently. And so I was inspired by this regulation. And in addition to these transparency measures, I come with the idea of fairness, and I also have a concrete approach to what I understand by fairness. And I argue in my paper that intermediaries should limit the possibility of exclusion of protected classes in advertisements related to sectors that have a high incidence of discrimination. And here I specifically talk about housing, credit, and the employment sectors. And I was inspired this time not by a regulation specifically, but instead by what happened to Facebook in the United States. So when Facebook settled those class actions that I mentioned in the beginning, they basically accepted to create a new portal in which advertisers or companies willing to promote their housing, credit, and employment sectors would not be able to exclude protected classes from receiving it. So they created this entire new portal to accommodate the need to target people and the need to comply with anti-discrimination laws. And I thought it was something that this private company did, and maybe it should be translated in regulations. I thought it was a creative solution that could translate well in regulations. And I finalized by auditing tests or auditing measures. Well, in my view, transparency and fairness measures are starting points in the fight against discrimination in targeted advertisements. So these measures should help interest parties to assess which demographic grounds were taken into account in the delivery of a certain ad. In addition to restricting the exclusion of a protected class in sectors that have high incidence of discrimination, right? But I believe that these measures should be complemented with a more institutionalized forms of auditing tests. And I believe that companies, they should allow anti-discrimination national watchdogs to conduct external and independent auditing tests to provide a comprehensive picture on the state of discrimination in targeted offers. This practice is already done offline to a very less extent in the European Union and member states of the European Union, but it's something that it's been evolved in the past year. It's something that has been done much more intensively in the United States since the 60s. But it has proved to be an interesting tool to address discrimination, and I think it should be implemented in our online universe. And I give more reasons for that in my article. I will not overwhelm with you here. But I really believe that a global and consistent approach to auditing tests is required in order to create a fair picture of what is going on in terms of discrimination in targeted advertisement. So I conclude by saying that my purpose in this article was to bring to attention that the issue of discrimination in the practice of targeted ads in the light of anti-discrimination laws. I believe that the topic is consistently approached by data protection laws, but also now, especially now, by competition law. And I find that the anti-discrimination law field has a lot to contribute to the debate. And so this was one purpose of my paper, but also to highlight that our legal framework is not very clear yet whether this legal framework is sufficient to address the issue. And having reflected on this uncertainties, on this insufficiency, made me really think of alternatives to the practices. And that's how I came up with these three possibilities of transparency, fairness, and auditing measures. And that's all from my side. I will interrupt here the sharing of my screen and I will come back. Here I am. And I hope you enjoyed. I don't know if I was clear enough. And if you have any comments or any questions or suggestions, I'm more than welcome.
Yeah, thank you so much, Anna. It was really a rich presentation, and you actually raised a lot of points that I've been wondering myself. Really bringing together these two fields, or these two issues of EU non-discrimination law and targeted online advertising, and trying to close that knowledge gap. So I think it's really great that you're doing this research, and also that you're highlighting the difficulties in bringing them together and applying EU discrimination law in this context. And reading the paper as well, it really shouldn't be underestimated. So it's really important to be questioning this. So I'm sure there are questions. I see some already. Please feel free to raise your hand digitally, don't be shy, or mention in the chat if you'd like to ask a question. But I'll first give the floor to Maria for the first question. Thank you.
Thank you, Ana Maria. Thank you, Lottie. I definitely share your view on how important this topic is. But in fact, I've been taking notes, and I have a lot of questions, and I'm not sure I should put them in the chat. But anyways, let me see. I have 5, but you don't have to answer them. But they are more. The first one is, and in any case, I think this is a paper, or this is an issue, because also it takes place when you study, for example, contract personalization, which is, how do you draw that very fine line between adjusting and targeting your future clients and discriminating against certain groups? Because we know that, let's say, this specific this specific targeting brings a lot of potentials, but we also know that it raises a lot of concerns. So defining, I'm not asking you for the definition, because I don't think anybody has it for now, but I think it's worth it to differentiate, because the whole, it's also my second question, but that you also mentioned, because that draws on the very fine line between differentiating and discriminating, because not all the discrimination is a differentiation, but not all the differentiation is a discrimination, and setting up what we mean by each of these concepts, I think it's fundamental in this. I also, let's say, my third comment refers to the variables. What are the variables that you have in mind? Is it only a matter of what the GDPR would qualify as sensitive data? That would go beyond that? Would that be variables that we understand are particularly sensitive, that then they would be special categories that would affect fundamental rights, and therefore that's fine? I mean, fine meaning that these would be the ones that we are, let's say, considering, or, for example, income would also be how do we define, or how do we bring the variables in? Then also let's say, my next comment, which is related to this, is on where is the continuum between, and here, this is for you guys who do this fundamental rights questions, but where is the continuum between the individual decision and the collective effect of all of us deciding? And my idea is, I do not have any obligation to allow everybody to come into my bar. But of course, when online, we all can decide that there's certain groups that we will not want in our bar, meaning that we want to conduct transactions with collectively, that could affect their fundamental rights. So let's say, where is the limit? Because on the individual perspective, let's say, traditionally in non-digital environments, all of this has been relatively flexible in the sense that fundamental rights in the horizontal relationships, and here I regret missing Aurelia, but I mean, in the horizontal dimension, like the scope is much broader. But where is this? Because that's exactly the case. I don't know if you saw it, but also like of Facebook of Airbnb in California, where they had to change the dynamic of sequencing of the information, for example, for the transaction, when they were realizing that certain names and certain racial profiles were not able to conduct transactions. So then they released the name and the let's say all the personal details of the person when you had entered into a contract. So that might be. And the last comment, and I apologize for the abuse, but is whether you are only thinking about social networks or also multi-sided markets where you also can enter into goods and services transactions. And thank you very much in advance. I don't expect an answer of all of them. Happy I read it.
Yes, thank you. Thank you for the questions. They are super interesting. And also, I have thought a lot about them as well. And so how do you draw the line of targeting client and discriminating? Well, I personally do not. The ones who do it are actually the regulations, right? So the regulations, in my view, are very clear that we cannot exclude. We can include in a form of a positive discrimination, of a positive action. We can include certain categories for sure, but we cannot exclude certain categories in certain situations. And these categories are very limited, at least in the framework of European law, right? So here I would say that the line for me are these protected categories, at least. So, and here I'm saying I would stick to the goods and services, because in the employment markets, we have the directive that expands this even more, right? So, for example, sexual orientation is included. And these distinctions as well between the directives are fictional for most member states, because most member states, for example, protect sexual orientation in the access of services and goods as well. But I would say that my line is at least what is provided by the anti-discrimination law framework, and in the access of goods and services, I would say sex, gender, I would say gender and ethnic origin, at least, even if we know that there are some nuances specifically related to gender, much more than the ethnic one, right? Because I cannot even think about a justification that would allow a differentiation based on gender in the access of goods and services. I can think about employment, for example. One possible exception to differentiate between, in a very plain, flat language, not being derogatory, but between white or black people. For example, if I want to create a theater piece, I can, in this situation, differentiate if the actor of this piece is necessarily related to a person that is white or black. So in this situation, because it's in the framework of employment. But so this is my line, and I know that I faced this question before, and some people told me I was not idealistic enough because I was not considering, for example, the line of income, as you mentioned, of like economic disparities. But I believe that at least if we have this line, we have already something, considering that it's so hard to make things move to progress in regarding anti-discrimination, right? So this is my line. And when you ask, and this is pretty much related to the variables I'm taking into account, and I really, in this article specifically, I really took into account the variables provided by the case law and by the EU anti-discrimination framework, not the GDPR one. Not the GDPR one, because it's, in my view, it's very vague. It's completely vague, and it's provided by, well, there are two dispositions in the recital of the regulation, and that's all. They don't provide like in which situation, and we are sure that this data can be used in several situations without being illegal if we look at anti-discrimination laws. And this comes to my argument in my article. We cannot make the GDPR enforced if we don't mobilize anti-discrimination laws. It doesn't make any sense, in my humble view. And where is the limit between collective and individuals? I'm not sure if I really grasp the meaning of this question, but perhaps I can relate it to the other questions, in the sense that there are grounds that may serve as proxies to the protected aspects. So, for example, you mentioned the names, right? And names are they are big proxies for, they can be already for gender for sure, because most names are genderized, but also to national origins and to ethnical backgrounds. So yeah, it's the question of proxies is something that I didn't resolve yet in my own mind. And I adapted this article, and I didn't want to mention in this article, and perhaps it's going to be something for the future, but all the possibilities we have with big data, for example, that we can create categories from, well, we can discriminate based on data that is not protected actually by, or grounds that are not protected. And I didn't want to refer to this sort of practice. And I want to stay in the step behind, the step where the companies, they choose who they want to reach, because it made my life much simpler, actually. That's the reality. Perhaps one day I really want to do this, and I want to bring with me to write this article, a scientist or an engineer, actually. To my talk, because I need the help of this person to write such a legal analysis, I believe. And if I just refer to social network or multi-sided markets, well, yes, it's true. I don't know, during I was shaped as a researcher in a center that study legal theory and legal philosophy as well. But they have a very practical or pragmatic approach of philosophy and legal theory. And their pragmatic approach is that theory only serves if there is a practical case to shed light into. So I always start my articles and my presentations by telling you a story, because it's the way I learned to do philosophy, actually. I really learned to be separate from abstract conceptions and to really dig into cases and to bring these abstract concepts to the concrete discussion. And that's why I use these two examples. But I would say that, well, probably there are several nuances in other markets, nuances that I'm not completely aware of. But I would say that the principles that I suggest, or the measures that I suggest in the last part of my article, they could be pretty much applicable without a big burden to these other different markets. And I hope I answered your questions. Thank you
so much. I have Sebastian. I think because of the time, I don't want to keep people for longer than we kind of said, but please feel free to stay if you'd like to continue the discussion. Yes, Sebastian, you can have the floor. Thank you.
Yeah, thank you. And thanks a lot, Anna Maria, for the great presentation. There was something I just thought about, but framing, I mean, using anti-discrimination regulation to deal with these issues is all the more essential and important because when you think about it, the GDPR would not apply to a lot of data that is being inferred. So not directly provided by the data subjects, but really inferred. And so even so the non-discrimination regime would be even more useful in that sense because it does not concern personal data as such. But yeah, and I don't know if that's something that that you have included in the paper, or and also I was thinking about the DSA, the Digital Services Act, because in the end the 3 points that you mentioned in the article with transparency, fairness, and auditing, there are the 3 of them also present in the proposal for the DSA, and the possibility, for example, for researchers and not only enforcement agencies, but also organizations protecting consumers or academics to audit themselves also.
Oh, thank you for this call. I'll take a note here because I didn't have time to really dig into this regulation. And if it's the case, it's definitely something I should mention.
Yeah, and it does include like more transparency requirements. I mean, you mentioned it in the article, saying that also the European, and the European Data Protection Officer had recommended to prohibit targeted advertising and stuff like that.
Yes. Thank you, Sebastian.
Thank you for the presentation.
Thank you. So I don't see any other hands up. I know that we are running out of time, but I have one question that I would like to ask, if possible. So I was struck by the recommendations you're making about transparency and auditing and fairness. And I see these coming back a lot in a lot of different recommendations on related issues, but not specifically maybe on targeted online advertising. And I wondered, because so to give you some background, I look at artificial intelligence and human rights issues, and I'm doing a comparative analysis of what regulations or recommendations are being developed in that respect. And alongside these 3 that you also that you already mentioned, I often see impact assessment coming up, and especially in relation to human rights related issues like discrimination. So I wondered, do you think that an impact assessment is something that could also help here, or do you think it's not as relevant for the kind of specific context of online targeted advertising?
Well, I think it's a very good call, and I think it could complement very well the auditing tests that I suggest, that it's a practice that happens already in offline markets, and it definitely could complement that in a positive way. So thank you. Yeah.
Thank you. So I don't know if there are any other questions. No?
There is someone who texts us. No.
I think that's it. Okay, so well, thank you all very much for joining us, and Anna Maria, thank you so much again for your presentation and for your paper. I really look forward to seeing it published. I hope you'll share it with us when it's out, so that we can all give it a read. We will be back with the next LiaNs seminar on the 5th of January, and that will be with Professor Caroline Kaufmann from Maastricht University. So if any of you would like to join, please feel free to let us know.